For the debate, I recognize the member for Ottawa-Vanier.
Thank you, Madam Speaker. I rise today to speak in strong support of Bill 112, Lydia's Law, the Accountability and Transparency in the Handling of Sexual Assault Cases Act. And I want to begin by acknowledging the survivors whose courage brought us to this moment. And also for the member for Waterloo for doing all that work and being so insistent that this is an important bill. Every survivor who came forward, every person who endured the trauma of reporting their assault, every person who waited months, sometimes years, for justice, that never came. The bill exists because those survivors deserve better from this province. Bill 112 is not radical legislation. It does not reinvent the justice system. It asks for something far more basic: accountability, transparency, data, action. It asks the government to finally do what the Auditor General recommended 7 years ago. 7 years. In 2019, the Auditor General identified serious failures in how Ontario handles criminal cases involving sexual assault and intimate partner violence. The recommendations were straightforward: track delays, understand why cases are being stayed or withdrawn, collect proper data, and allocate resources accordingly. The government agreed to those recommendations, and then they did nothing. Madam Speaker, that failure has consequences. Real people are paying the price for this government's refusal to manage our court system properly. Last year alone, 1,639 sexual assault cases in Ontario were withdrawn or stayed before trial. Think about that. That represents 34% of all sexual assault cases received in this province. That's an awful lot. Think about what that means. Those are not numbers on a spreadsheet. Those are survivors who came forward despite enormous fear. Survivors who relived traumatic experiences in police interviews. Survivors who prepared themselves for court. Survivors who put their lives on hold, waiting for justice. And then their cases disappeared. No trial, no resolution, no accountability. Too often, no explanation. Madam Speaker, in 2015, there were 57,000 charges placed that fall in the category of crimes against a person, such as homicide or sexual assault. In 2025, 80,000 charges were placed for that same category. At the same time, the withdrawal rate has risen from 33% to 48%. For all criminal cases, the majority are now stayed, withdrawn, or dismissed. Court delays are not simply administrative inefficiencies. They are barriers to justice. They undermine public confidence in our institutions. They weaken prosecutions, and they re-traumatize survivors. And in some cases, they allow accused individuals to walk free without their case ever being heard. Cases like those of the woman whose assailant walked free when her sexual assault case was stayed because there was no courtrooms available for 2 of the 3 days scheduled for the trial. She testified, but the trial was not completed within the 18 months required by the Supreme Court. And this government likes to talk about tough on crime. The Premier likes to hold press conferences about public safety, but you cannot claim to support victims while starving the justice system or the resources and oversight it needs to function. You cannot increase policing while failing to increase court capacity accordingly. And you cannot allow courtrooms to sit unavailable, allow staffing shortages to persist, and then pretend to be surprised when the backlog grows worse year after year. And you certainly cannot ignore warning signs for nearly a decade and then claim this crisis came out of nowhere. Madam Speaker, the effects of court delays reverberate throughout the entire justice system. Families remain trapped in uncertainty. Survivors are forced to relive some of the worst moments of their lives over and over again while waiting for proceedings that may never happen. Crown attorneys face impossible caseloads. Judges struggle with mounting backlogs, and confidence in the administration of justice erodes further every single day. We know this problem is getting worse. In 2025, sexual assault cases had the second highest average number of days to resolution in Ontario at 352 days. The only category with longer delays was other sexual offences at 374 days. That should alarm every member in this House. Because when justice is delayed to this extent, justice is denied. Now, when concerns have been raised about delays causing cases to collapse under Jordan timelines, the Attorney General's office has argued the judicial delays for delays are exceptionally rare, reportedly around 0.1%. But there are two serious problems with that argument, Madam Speaker. First, those figures likely do not account for cases proactively withdrawn by the Crown to avoid an anticipated Jordan application. And second, and this is critically important, rarity does not make the problem insignificant. If even one survivor sees their case collapse because this government failed to provide adequate resources to the courts, that matters. Even if one complainant spends years preparing for trial only to watch the case disappears because of systemic delays, that matters. And when we are talking about sexual violence, crimes that are already vastly underreported because survivors fear they will not be believed or supported, these failures become even more damaging. Madam Speaker, many survivors already faced overwhelming barriers to reporting sexual assault in the first place. Fear of retaliation, fear of public scrutiny, fear of reliving trauma in open court, fear of not being believed. And when someone makes the extraordinary difficult decision to come forward, the justice system owes them a process that is timely, respectful, and functional. Too often, Ontario is failing that test. That is why this bill matters. While drafting my private member's bill, the Protection from Coerced Deaths Incurred in Relation to Human Trafficking Act in 2023, I got a first-hand look at how our judicial system puts up barriers for survivors at every turn as they seek justice. Lydia's law works to take down a few more of those roadblocks. Bill 112 would require the Attorney General to publicly report on progress implementing key recommendations from the Auditor General. It would require meaningful tracking of delays, stays, and withdrawals. It would require the government to identify where delays are occurring and why. In other words, it would force this government to finally understand the problem it has spent years ignoring. Because understanding a problem in the first place is the first step towards solving it. And right now, this government refuses to even take that first step. The bill would also require every police service to inform sexual assault complainants aged 16 and older about Ontario's independent legal advice program. For many survivors, navigating the justice system is overwhelming. They are expected to understand complex legal processes while coping with trauma, uncertainty, and fear. Independent legal advice can help survivors understanding their rights, understand the court process, and make informed decisions about how they want to proceed. And it becomes even more essential when this government continues to leave Ontario's legal aid system under-resourced and overstretched. Over the past several years, legal aid clinics, community legal services, and frontline advocates have repeatedly warned that they do not have the resources needed to meet the demand. Survivors who are already struggling to access justice are too often left without adequate legal support, particularly those from low-income, marginalized, newcomer, or rural communities. That matters too. Because survivors navigating the justice system should know that what supports are available to them. They should not be left to navigate a deeply intimidating process alone. So when we talk about ensuring that complainants are informed about the independent legal advice program, we are talking about filling a gap that this government itself has widened through chronic underfunding. The legislation also calls for a review of how effectively the Victim Quick Response Program supports survivors of domestic violence, sexual assault, and human trafficking. Again, this is about accountability. This is about asking whether our system are actually serving the people they were created to support. Madam Speaker, this issue cuts across party lines. This should not be political. No government should be comfortable with a system where the thousands of sexual assault cases never make it to trial. No government should be comfortable operating without complete data on why cases are being withdrawn. And no government should be satisfied with offering survivors apologies instead of action. This government has had 8 years to address these concerns. 8 years. That is nearly a decade of survivors being left in limbo while recommendations sat on a shelf collecting dust. Meanwhile, the backlog worsened, the delays worsened, and survivors continued paying the price. Madam Speaker, we have seen before how public accountability can drive meaningful reform. In 2017, the Globe and Mail investigation into police services improperly classifying sexual assault complaints as unfounded forced institutions across Canada to confront systemic failures in how survivors were treated. Transparency mattered then, and transparency matters now. Survivors need to trust that the government will have their back, that there will be support for them, that they won't have to be re-traumatized over and over again, that their case will be heard and that they will get justice. I care deeply about those issues. I've done some work on human trafficking, and some of the stories I've heard really prompted me to act. I have 3 daughters, and everybody knows you have girls. You need to support that bill. Thank you, Madam Speaker.
For the debate.